So the complete DIMS reads, the complainant stated she did not feel pain at the time of the incident since she was fighting the defendant off of her, and that the officer observed the complainant shaking and crying, and the officer said, due to his training experience, I know being grabbed and bruises being left on your body causes pain.
Hey there, welcome to the Courtroom Files. So we have an interesting probable cause hearing in front of Judge Fleischer. We have a defendant who is there for assault of a family member, and probable cause is presented, and the judge finds it fairly quickly. A little while later in the docket, though, his lawyer comes in and brings up some interesting details that weren't necessarily part of the original PC, which gets the judge thinking again. So take a look at this and let us know what you think, because we've got a lot of different ways we can read the behavior of the people involved. And by the people involved, we don't necessarily mean the complainant and the defendant. We mean the police and the district attorney's office. But let us know what you think. Again, we're Switzerland here. We'd rather hear what you have to say. So put that in the comments. Put a thumbs up on the video if you enjoy it. Consider subscribing to the channel if you haven't already. Doing those two things help other people find our videos. And let's go ahead and roll the game film.
Mr. Corral, you are charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 18th, 2024, officers were dispatched to a family assault and made contact with the complainant, who stated that she and the defendant are dating. The complainant stated that they got into an argument when the defendant grabbed the complainant's arm and squeezed, causing pain. Complainant stated she punched and struck the defendant to get away. The complainant stated that the day prior they had gotten into an argument and the defendant grabbed her by the arm and squeezed while the complainant fought to get away. The officer observed bruises on the complainant's arm.
Got it. Mr. Corral, I'm going to find that there's probable cause to go forward with your case, and I'm ordering you as a condition of your bond not to have any contact with this person and not to be in possession of weapons. If you violate these conditions, I'm going to put you in jail by revoking your bond. Do you understand? I don't see a protective order that's been issued. Has one been issued in this case?
I see it as of 1019, Judge.
No, but it's not been signed. Corral. Yeah. Do you guys see it or no?
That's
All right, Mr. Corral, I'm entering in what's called a mattress order of emergency protection that identifies Ms. Cabrera as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the East Tex Freeway Apartment 4304. If you violate this court order, the state can and will file additional charges against you, including a violation of protective order. It's one of the worst cases you can pick up. So know what you can and can't do before you leave this place. Do you need a court-appointed lawyer, Mr. Corral? Okay, I'll appoint your lawyer today. Do not leave until you sign all our bond conditions. Otherwise, a warrant will issue. Please.
You don't do it, sign this, no.
Can you file no contact and no weapons?
Yes, Judge.
Yeah, sorry, Mr. Pons, I'm just,
The affidavit and that she said she didn't feel pain.
I don't know. All I know
No, I'm
is
telling
that
you, that's why I'm up here challenging the PC on that one. There's an affidavit, a complaint that's provided.
There's an affidavit. Because in the
Hey,
DIMS,
this is on Corral? This is a new case, right?
It's a complaint, so it happened in October 2024.
How did it get an affidavit here so quick?
Because it's a complaint. The officer's affidavit on the complaint. He states that she stated she didn't feel any pain because she was fighting him.
I
As
thought,
well.
but you said that you did feel pain.
the complete DIMS.
I wouldn't, or that's the problem, is the DIMS is maybe contradicting or inaccurate or different from the affidavit that I'm talking about? That the officer filed?
So the complete DIMS reads, the complainant stated she did not feel pain at the time of the incident since she was fighting the defendant off of her, and that the officer observed the complainant shaking and crying, and the officer said, due to his training experience, I know being grabbed and bruises being left on your body causes pain. So according to the full DIMS, the complainant didn't say she felt pain. She said that she didn't feel pain at the time of the incident because she was fighting the defendant off of her. And that's what the full DIMS states. And the officer, based on training experience, saw the bruises on her and being grabbed and squeezed and came to the conclusion that it caused pain.
It could also be the exact, that what she said was, I was shaking and crying because I was fighting him. She's the one that says that.
I mean, I get it, like at the time, you're in the stress of the excitement, so you're not feeling it, but then after,
That's not what she said though, or that's not what
Stress.
was going on.
Your Honor, the key thing the officer observed were the bruises on the complainant's arm. He observed the bruising and then came to the conclusion based on that. And what she told him, she did say that the defendant squeezed her arm. And based on that, her crying, shaking, and the bruising, he came to the conclusion that she felt pain due to that being squeezed.
I mean, taken as a totality, is that not sufficient for probable cause purposes?
I don't know. You have a sworn document where she says one of the elements is missing. And then everything else that he's adding is not in that
To
document.
be more specific, she's saying she did not feel pain at the time of the incident since you were fighting. She didn't say she didn't ever feel pain. She said at the time since she was fighting the defendant off of her.
But the officer
not in that.
asked- But the officer never asked, hey, do you feel pain? Why
And
wouldn't
it's
you
correct, the officer
ask?
never asked. He came to the conclusion based on totality.
Get it, but I don't know, I mean, I need to look up case law. I'm not sure. I don't know if that's enough. Because I mean, it's such a low standard for probable cause purposes, you know? I mean, I get that you're saying that it's not alleged the pain as an element, but taken as a totality.
I guess you're saying
No.
taking it as a totality. I'm saying that's a lot of speculation about stuff that's not in the DIMS or in the affidavit. Like you're making all these connections state.
I'm making the officer made the connection. He said in the DIMS, due to my training experience, I know being grabbed and bruises being left on your body causes pain. So
Right.
he made that
You
connection.
don't operate on hunches.
Right, and she's also stated that I was fighting him, so that could be because of her
I mean,
fighting.
here's the deal, like if I find no PC, right, they may just re-indict it though.
That's fine.
No.
That's their.
Kelsey,
Yes, sir.
did you see what's going on? So in this case here, the officer never asks her, do you feel pain? He assumes she does just because of bruising on her arm. And because I guess they're in the stress of the excitement. So at the time she doesn't feel pain, but after a while, he assumes that she feels pain because of bruising on her arm.
And on body worn camera, he never says, we don't know.
But well, I mean, this is a probable cause hearing. We haven't seen it. So he wants me to find no PC. If I do though, right?
Well, if there were visible injuries, we can go from there.
But he's saying that, you know, I mean, if it were like blood, like some kind of tearing of the skin, that's one thing. But bruising, is it possible to get a bruise without feeling pain?
Yeah, I do
You
it
know-
all the time. If you fall downstairs and you're embarrassed more than in pain, you might be crying or shaking because you're embarrassed or excited, but it's not because of you injuring yourself down the stairs.
But Your Honor, that also ignores that she did say the squeeze itself. He mentioning a fall, but in this case, we do have a specific statement about a squeeze.
She doesn't say that she's in pain because of the squeeze.
So
I
if you
mean-
play it out in front of a jury, you would always have that statement saying at the time she didn't feel pain. Whatever you said contradicting that, that's fine, but it would not take away that statement that eliminates an element.
That's what I'm saying.
So maybe a grand jury might find it different, but based on that DIMS, they have someone saying, I didn't feel pain. I think that's kind of like,
And Your Honor, I will say at the time, we don't have the full OR, so if you want to find no PC, we can revisit it. And if we want to re-indict it, we can.
Okay, all right, I'll find no PC. Okay.
Hey, thanks for watching. If you enjoyed that video, do please take a moment to like, subscribe, and leave a comment on the video. We'd really appreciate that. And if you want to keep the fun going, check out the video on the screen right now.